Hello everyone, my name is Maxim. I'm a legal operations specialist here at Howley, and today we're going to discuss union and collective bargaining agreements in the United States. These documents, or better to say, this document, we'll discuss it further, is one of the utmost important documents in United States labor and corporate law. So, what is it? Let's discuss it. Let's begin with the procedure. So, what is collective bargaining? As you can see on this slide, it's a negotiation process between employee and employer, but on what subject? The collective bargaining is the process where a labor union, representing a group of employees, negotiates with an employer about working conditions. Uh, Such a discussion may include wages, work hours, benefits, safety standards, and so on and so forth. Then the goal is to reach a agreement that balances the interests of both employees and employers. So who takes part in such a negotiation? Generally, it's the union bargaining team, members of each side's negotiation committees, and employer representatives or management attorneys. Sometimes, when such a balance cannot be reached, the federal mediators may be involved, or also they are involved in cases that are prescribed by law. For example, when we are speaking about CBAs in the field of governmental services or special fields of economy and so on and so forth. All of these procedure, it runs around mainly these five categories that are presented on this slide. The wages, of course, everyone needs money. Work hours, benefits for employees, working conditions, and the questions on dispute resolution procedures that are to be brought out of this negotiation and uh, are to be written inside of a final document that is called the CBA, the Collective Bargaining Agreement. What we need to understand and what we need to know are essential legal doctrines that exist in the United States law regarding uh, the bargaining procedure itself and a collective bargaining agreement also as the final result of such a procedure. Let's start with the right for to unionize that is prescribed through National Labor Relations Act and all NLRA. This is basically the doctrine that gives a right for employees to unionize, bargain collectively, and engage in concerted activity. It protects workers' rights to form unions, requires employers to negotiate with certified unions, and generally prioritizes the role of labor unions in the United States. The second is the duty to bargain in good faith. This is the doctrine that comes out of a legal custom, and it means that both sides must make sincere efforts to reach an agreement, and it is not required to make concessions. So that employers must meet, provide information, and negotiate seriously, and unions must participate in the bargaining procedures meaningfully, which means with the intention for getting a balanced result for the employees that they are representing. Excluding bargaining representative doctrine means that the union generally in most states in the United States is the sole representative for all employees in the bargaining unit, for all their members. Employer cannot negotiate individual contracts or bypass the union. Federal preemption doctrine means that the federal labor regulations overrides conflicting state laws. But Statute doctrine works in an interesting way where uh, its prescriptions are to be used only if they significantly result in better working condition for an employee uh, that is inside of a labor dispute. What does it mean? For example, if in-state legal regulations differ from federal legal regulations and federal legal regulations, they result in better working conditions for an employee, then federal preemption doctrine is to be used. And but it works for in both ways. The Steelworkers Trilogy, or arbitration doctrine, is the doctrine that arbitration is favored as primary method for resolving contract disputes and also labor disputes that exist between employees and employers, and the way of their resolution is primary arbitration throughout the provisions of CBA agreement. Uh, Arbitration clauses, therefore, in the CBAs are enforced, and disputes usually are resolved outside courts. The contract supremacy doctrine means that CBA overrides all the time company policies or individual agreements that exist in the company. This means that employer must follow CBA even if internal policies differ from its provisions. The next doctrine is the doctrine of the duty of fair representation, which means that labor union, must represent all employees fairly without discrimination or negligence. The negligence, I'm sorry. Employees may sue unions for bad faith handling of grievances. The deferral doctrine means that NLRB often defers disputes to arbitration if the CBA provides procedures for such arbitrations. It encourages resolving disputes within the CBA grievance or arbitration system that's prescribed and used and enforced in the CBA. Management rights doctrine means that employers, they all in all retain control over business operations unless it is limited by the CBA. It establishes the management rights clause as a standard part of a CBA agreement. So, after all discussions are being run, the collective bargaining agreement is generally born. It is a legally binding contract between a labor union and an employer that defines the rights, responsibilities, and working conditions for employees in a bargaining unit. Uh, in legal practice, throughout different documentation and sometimes even in state laws, you may find the term union bargaining agreement, not collective bargaining agreement. How do they differ? They do not differ at all. These are two terms for the same document that generally used throughout legal practice. The thing is that union bargaining agreement is more HR-ish thing. It's the way that mostly HRs name it, and the collective bargaining agreement is the way that is the name that is given to this document by lawyers. That's generally all the difference. But as any legally binding contract in the United States, a collective bargaining agreement is being regulated by several legal acts. On the federal level, this is the Fair Labor Standards Act, the Labor Management Relations Act, which we discussed before, the Federal Arbitration Act, Civil Rights Act, and Employee Retirement Income Security Act. Uh, in the column provisions, you may see what do they generally regulate, but the thing is that the doctrines that we've just discussed are based are more valuable base for collective bargaining agreements that general regulations themselves, since the question of the bargaining procedure and of collective bargaining agreement itself, it's the question of a of a contract that exists in the fields of labor and civil law, and we've discussed it previously in our previous lectures that United States law, civil law even, is really very contract based, and all the provisions of the contract may be changed by the parties for their own sake, with uh, but these provisions that are to be changed cannot violate law in any way. So generally, for example, if we are speaking about in state specifics and regulations, state regulations, are they mere regulate questions that are more connected to the field of governmental services and governmental workers than to the private sector. Private sector is mostly not regulated at all on a state level. But if we're speaking about, for example, Colorado, in this state, county employees can enter into collective bargaining agreements that last from 12 to 60 months. But thing is that they can do this; it's their right. But generally, they are not obliged to do this. But in, for example, Montana, union agreements may include membership or dues requirements, and they are obligatory for employees. But the question that's related to the governmental, the state sphere for, of labor relationships, uh, the regulation of working conditions, wages, and etc. for governmental employees are generally regulated by specific acts that exist depending of the sphere of activities where such employees work. Okay, so the typical contents and structure of collective bargaining agreement are those that you see on this slide. The wages structure, work hours and schedules, union rights, benefits, management rights, seniority rules, discipline and discharge, and grievance and arbitration procedures. We'll speak about we'll speak about those that are marked in more orangish yellowish color, since their importance in collective bargaining agreement is much higher than in those that are colored green. Why is it so? Because the wage structure, union rights, management rights, and grievance and arbitration procedures were historically these questions that forced United States government in late 30s after the Great Economical Depression to force legal regulation of collective bargaining agreements and collective bargaining as procedure at all. These were these main questions that existed in this time, and historically and traditionally these are the questions that inside of a of CBA as a document are things the document pays attention to in the most significant way that's possible. So, regarding the wages and hours in collective bargaining agreements, generally uh, describe the base pay rates that may exist in a company, annual wage increases, overtime rules, the payment for overtime work. For example, employees might receive uh, overtime pay after 40 hours of work per week or for working certain night shifts. That's how the union and the employer will go come to the conclusion on which is better for them. The next is the overtime rules that I've just told before, the shift differentials, breaks and lunch periods, scheduling guidelines, and so on and so forth. This is in the section of this is what is common in the section of wages and hours in CBA. Regarding the union rights, these are the sections generally related to the right to represent employees, access to employees lists so that the labor union may know who works in a company, access to the workplace, generally for providing um, safety checkups and working condition checkups and the workplaces where the members of the union work. The next is the ability to hold meetings. But it means that this is the ability for holding meetings with workers that do work on in such a company that is a part of a CBA agreement, and employer will not make any problems for running these meetings. uh, Participation in grievance handling, and the right to negotiate changes to the collective bargaining agreement. The management rights section is generally and most commonly related to operational control, enforcing companies' policies, setting schedules, working schedules, it's meant, assigning work, which is generally connected to the assigning of labor roles and working functions in the company, hiring and firing decisions, the rights on which a person may be hired and fired from work. Generally, there is a thing also called the grievance procedure. So, what is it? Grievance procedure is the procedure. Grievance and arbitration procedures are the procedures for resolving disputes, and it works generally like that. The employee discusses issue with his supervisor. The union representative becomes involved into this situation. The higher level management is reviewing the whole conflict, and the arbitration by the neutral third party is being held. Generally, generally, this is the main scheme on work in which the grievance and arbitration procedures work in for resolving disputes inside of a company. But I need to point on the fact that CBAs pretty generally pretty specifically describe the grievance and arbitration procedures that are to be held in case of any conflicts that may appear in the workplace. And these are really specific. So this is more the question for a specific CBA agreement and how the grievance and arbitration procedures are described in it. Here you can see a few cases, legal cases, and just practical examples on why the collective bargaining agreements are important and how do these documents help to protect employees' rights and also employers' rights. Uh, First is the Volvo Trucks and United Auto Workers 2021 strike, which had been held in Virginia. The whole plant went on strike during the contract negotiations. The new CBA in that situation included wage increases, bonuses, improved safety measures, and better benefits. Why it matters? It shows that the union action and collective bargaining can directly improve pay, benefits, and working conditions. The national CBA between miners and operators included wage increases, pension and health benefits, safety standards, and paid leave. This is just a historical example, one of the biggest protests in the United States that ever had been held regarding the CBA issues uh, that had been held in the United States. It just demonstrates the culture of the unionizing, fighting for one's labor rights, and achieving their results throughout CBAs for employees in the United States. So, let's go to the general conclusions about the theme that we've just discussed. The bullet points are: CBAs are essential tools in labor management relations, providing legally enforceable agreements that define wages, benefits, work hours, and conditions of employment. Union bargaining agreements functionally work the same as CBAs, emphasizing the union's role and the employee's exclusive representative, functionally and generally, essentially also. Negotiation process ensures that both employees and employers have a voice in their relationships. Good faith bargaining is legally required under federal law. CBAs protect employees by clearly defining their rights, grievance procedures, and arbitration mechanisms, ensuring good disputes are resolved fairly. And also, federal and states laws, they really interact with CBAs. Federal laws set minimum standards, while state laws may provide additional protections or cover sectors excluded from federal law regulations. So I hope you've got something new for yourself and this lecture had been interesting for you. See you soon with new lectures.